Patriots. The Supreme Court just issued an order in one of the most important Second Amendment cases you've probably never heard about. And what's happening right now could either be a massive win for state sovereignty and gun rights, or a complete betrayal by the Trump administration. We're talking about Missouri's Second Amendment preservation Act, a law designed to protect gun owners from federal overreach. The Supreme Court just denied emergency review for the second time. But here's the twist. The Trump DOJ made a promise to the Supreme Court about what they'd do if review was denied. The question is, will the Trump administration keep their word? Or will Missouri gun owners get stabbed in the back? Before we break down this developing situation, smash that subscribe button. We're fighting for state sovereignty and gun rights. Let's get to 700,000 subscribers. First, I want to wish everyone a Merry Christmas. I hope you had an amazing time with family and friends. Now let's dive into this critical case. What is SAPA? Before we get into the Supreme Court's decision, let me explain what SAPA laws are, because understanding this is crucial to understanding why this case matters. SAPA stands for Second Amendment Preservation Act, and it's one of the most aggressive state-level strategies to protect gun rights from federal overreach. Missouri passed their SAPA law back in 2021, and here's what it does. First, it sets Missouri's interpretation of the Second Amendment. The state is essentially saying, we believe the Second Amendment protects more than what the federal government claims. Second, it restricts state support and funding to federal agencies attempting to enforce federal gun laws that Missouri believes violate the Second Amendment. Third, it prohibits Missouri officers, agents, and government officials from helping federal agents enforce these unconstitutional federal laws. Fourth, and here's the most powerful part, it creates a civil remedy where a non-Missouri resident can sue a Missouri official who helps enforce federal gun laws the state considers unconstitutional. Do you see what Missouri did here? They gave enforcement power to the people instead of state agents. If a Missouri cop helps the ATF enforce an unconstitutional gun law, you can sue that cop. This is brilliant state-level resistance to federal tyranny. The federal government's ATTA SCOTUS, of course, the Biden administration hated this law. They immediately filed a lawsuit challenging Missouri's SAPA law. The Biden DOJ argued that Missouri couldn't interfere with federal law enforcement, couldn't tell state officials not to cooperate with federal agents, and couldn't let citizens sue state officials for enforcing federal law. The case went to federal district court, and guess what? The district court sided with the Biden administration. They struck down Missouri's SAPA law in its entirety and issued a permanent injunction blocking the entire law from taking effect. Missouri appealed to the Eighth Circuit Court of Appeals and asked for a temporary stay, meaning they wanted the SAPA law to remain in effect while the appeal was pending. But the Eighth Circuit refused to grant the stay. So Missouri went to the Supreme Court for the first time seeking emergency relief. They needed the Supreme Court to step in and allow their SAPA law to stay in effect during the appeal. And what did the Supreme Court do? They issued an 8-1 order denying the emergency stay. Only Justice Clarence Thomas voted to grant the stay. Only Thomas stood up for Missouri's sovereignty and gun rights. This was devastating. It meant Missouri's SAPA law would remain blocked while the case continued. The Eighth Circuit disaster after the Supreme Court denied that first emergency request. The case went back to the Eighth Circuit for full review. The Eighth Circuit held oral arguments and then issued their ruling, and it was a mess. Here's what the Eighth Circuit said. They found that the structure and operation of Missouri's SAPA law was valid. In other words, Missouri had the legal authority to pass this kind of law. But then they struck it down anyway. Why? Because they didn't like the underlying purpose, which was to protect the Second Amendment. Think about how insane that is. The court admitted Missouri had the authority to pass the law, admitted the law structure was legal, but struck it down because they disagreed with Missouri's interpretation of the Second Amendment. The Eighth Circuit also made another outrageous finding. They said that Missouri state officials could be sued because the state played a role in enforcement of federal law by simply complying with Missouri's SAPA law, which told them to do nothing. Read that again. Doing nothing is enforcement, according to the Eighth Circuit. They found that compliance and non-action was still enforcement, and therefore Missouri could be held accountable. This is judicial activism at its worst. Missouri goes back to SCOTUS after this terrible Eighth Circuit decision. Missouri went back to the Supreme Court for a second time. They filed another petition asking the Supreme Court to review the case and correct the Eighth Circuit's errors. Missouri made powerful arguments. First, the Eighth Circuit violated clear Supreme Court precedent by striking down a law whose structure they admitted was valid. Second, the Eighth Circuit's finding that non-action equals enforcement contradicts basic logic and constitutional principles. THIRD. This case involves critical questions of federalism, state sovereignty, and the limits of federal power. But here's where things got really interesting. When Missouri filed their petition, the Trump administration had just taken over from the Biden administration. So now the Trump DOJ had to decide, would they continue defending the Biden administration's attack on Missouri's gun rights law, or would they switch sides and support state sovereignty? The Trump DOJ's RSPO NAC for months. The Trump DOJ stalled. They kept asking for extensions at the Supreme Court level. Missouri waited and waited for the Trump administration's response. Finally, the Trump DOJ filed their brief. And patriots, it was mixed news. On one hand, the Trump DOJ continued to argue that parts of Missouri's SAPA law are invalid and that the Supreme Court should deny review. They essentially sided with the lower courts against Missouri. But on the other hand, they made an interesting concession. They told the Supreme Court, having reevaluated this case, the United States has concerns about whether the judgment below extends too far and enjoins applications of the Act that do constitute mere non-enforcement of federal law protected under the anti-commandeering doctrine. Translation: the Biden administration's complete injunction against the entire SAPA law went too far. Some parts of the law should be allowed. The Trump DOJ promised the Supreme Court, if you deny review and send this case back to the district court, we will move to narrow the scope of the permanent injunction. We'll release parts of the judgment and allow some of Missouri's SAPA law to take effect. This was a big promise. It meant that even though the Trump DOJ opposed some of Missouri's law, they were willing to let other parts stand. Missouri responded by pointing out, this is exactly why the Supreme Court should grant review. If even the Trump DOJ admits the lower court judgment is too broad, the Supreme Court needs to provide guidance. Missouri also raised a critical concern. What if the Trump DOJ doesn't keep their promise once this case is denied and sent back to the lower court? The Supreme Court's DECISO and, unfortunately, Missouri's concern might have been justified. The Supreme Court issued their order. They denied review to Missouri's SAPA case for the second time. The Supreme Court essentially took the Trump DOJ at their word and said, okay, we'll deny review. Go back to the district court and narrow that injunction like you promised. The Supreme Court sent notices to the Eighth Circuit and the Missouri District Court officially informing them that the petition for certiorari is denied and the case should proceed at the lower court level. So now the ball is in the Trump DOJ's court. They made a promise to the Supreme Court. Will they keep it? The broken promise. Here's the problem, patriots. As of right now, the Trump DOJ has not moved to narrow the injunction. The Supreme Court denied review. The case is back in the district court's hands. But the Trump DOJ hasn't filed any motion to release parts of the permanent injunction like they promised. The complete Biden-era injunction blocking Missouri's entire SAPA law is still in effect. Now, it's possible the Trump DOJ is just taking some time to prepare their motion. Maybe they're being careful about how they word it. Maybe they're coordinating with Missouri officials. But it's also possible, And this is what Missouri was worried about, that the Trump DOJ never intended to keep their promise. Maybe they just told the Supreme Court what they wanted to hear to get the case denied. This is exactly the kind of thing that makes gun owners skeptical of the Trump administration on Second Amendment issues. They say they support gun rights, but then they defend federal overreach and break promises to the Supreme Court. The Trump DOJ has defended the NFA in multiple cases. They opposed the Peterson suppressor challenge. They defended SBR restrictions in Rush and Robinson. And now they might be breaking their promise on Missouri's SAPA law. What happens on X to so? Where do we go from here? Immediate future? All eyes are on the Trump DOJ. Will they file a motion in the Missouri District Court to narrow the permanent injunction like they promised? If they keep their promise, parts of Missouri's SAPA law could take effect. Missouri officials would have legal protection to refuse cooperation with federal gun enforcement. Missouri residents could exercise their rights under the law. If they break their promise, Missouri's SAPA law remains completely blocked. The Biden injunction stays in place. And gun owners will know the Trump administration can't be trusted. Missouri officials and Second Amendment advocates are watching closely. If the Trump DOJ doesn't act soon, expect them to file motions asking the court to compel the administration to keep their promise. There's also the possibility that Missouri could go back to the Supreme Court again and say, the Trump DOJ broke their promise. You denied our case based on their representation to you. Now they're not following through. Why this matters for all STHL, me explain why Missouri's SAPA case matters for every state and every gun owner. First, state sovereignty. This case is about whether states have the power to resist federal overreach. If Missouri can't protect its citizens from unconstitutional federal gun laws, then states have nay sovereignty. Second, the anti-commandeering doctrine. The Constitution prohibits the federal government from commandeering state officials to enforce federal law. Missouri's SAPA law is based on this principle. If Missouri loses, the anti-commandeering doctrine is weakened. Third, other SAPA laws. Multiple states have passed or are considering SAPA laws. If Missouri's law is struck down completely, it threatens similar laws in other states. Fourth, federal gun control. If states can't resist unconstitutional federal gun laws, then federal agencies have unlimited power over gun rights regardless of what state law says. Fifth, trust in Trump administration. If the Trump DOJ breaks their promise to the Supreme Court, it proves they can't be trusted on gun rights despite their rhetoric. This case is a test of whether states still have meaningful sovereignty or whether the federal government has total supremacy. What gun owners should DOF? You're a gun owner, especially if you live in a state with a SAPA law or considering one. Here's what you need to do. First, contact Missouri officials and encourage them to hold the Trump DOJ accountable for their promise. Second, contact your state representatives and push for SAPA laws in your state. Don't wait for the federal government to respect your rights. Third, support legal organizations fighting for state sovereignty and gun rights. These battles are expensive. Fourth, spread the word about this case. Most gun owners don't even know SAPA laws exist or what's at stake. Fifth, hold the Trump administration accountable. Don't let them get away with empty promises and broken commitments. Sixth, prepare for the long game. These constitutional battles take years. We need sustained engagement, not just short-term outrage. All right, patriots, that's the complete breakdown of where Missouri's SAPA case stands after the Supreme Court's second denial. Let me summarize the key points. Supreme Court denied Missouri's SAPA review for second time 8-1 decision. Trump DOJ promised to narrow Biden-era injunction if review was denied. Supreme Court took Trump DOJ at their word and denied the case. Case is now back in district court hands. Trump DOJ has not yet fulfilled their promise to narrow injunction. Missouri's entire SAPA law remains blocked under Biden-era judgment. This is a test of whether Trump administration will keep promises on gun rights. The next few weeks are critical. Will the Trump DOJ keep their word or betray Missouri gun owners? Missouri officials are watching. Gun rights advocates are watching. And the Supreme Court might be watching too. If you found this breakdown valuable, smash that like button. Share this with every gun owner you know, especially those in states with SAPA laws. Subscribe and hit that notification bell for updates when the Trump DOJ makes their move. Comment below. Do you think the Trump DOJ will keep their promise? Or will they break their word to the Supreme Court? I want to hear your predictions. Remember, state sovereignty and the Second Amendment are under constant attack. We must remain vigilant and hold all administrations accountable, including administrations that claim to support gun rights.